clarify, examining corps, C-O-R-P-S, the body of examiners. But of course, there's also a court. In fact, there's several courts. Let's talk a little bit about that. You mentioned the PTAB already, the Patent Trial and Appellate Board, which is a recent body. Let's go back to a more traditional, typical court, a federal court, which arises in the context of litigation. So we've talked about patent prosecution, and the other main area of practice is patent litigation. How does that relate to prosecution?
It's interesting because the patent system itself is really, you can think of it as being in two stages. You've got the first stage, which is the patent prosecution, patent acquisition stage. Mm-hmm. And once you get a patent, then it's not self-actuating. Right. That's only your first stage. Then you have to go to a federal district court because the federal district courts have exclusive jurisdiction on patent matters. And so you then move to the second stage. And in the second stage, you as a patent owner can bring a patent infringement claim against somebody for patent infringement. So it's really a two-stage system. It's important to understand, however, that the two stages are very much related to each other. Mm-hmm. So in the second stage, which is the patent litigation stage, everything that happened in the first stage can be revisited. So it's not just infringement that is at issue in the second stage. In fact, in the second stage, you can go back as a defendant and raise all the issues related to patentability. And you can say, hey, you sued me on this 124 patent, referring to the last three numbers in the patent number, because often mm-hmm. the way patent attorneys refer to patent numbers. Mm-hmm. And the defendant says, hey, you've sued me on this 124 patent, but I believe that this 124 patent claim that has been asserted against me is invalid. Why is it invalid? It's invalid because it doesn't satisfy the requirements for patentability, 101, 102, 103, 112, the basic statutes in Title 35 of the US Patent Code. So the second stage allows you to revisit everything in the first stage again as a defendant. And you can also argue that you are not infringing the claim. So the argument there is, even if the claim is valid, I don't fall within the scope of the claim and I'm outside, so I'm not infringing.
Yeah.
So one of the really important things that is easy to miss in the patent system, and this is perhaps one of the most important things as a student of patent law to keep in mind, is that because this is a two-stage system, patent prosecution, patent litigation, as a plaintiff in the second stage, as a patent owner and as a patentee in the second stage, you have to win on both validity and infringement. Yeah. You have to be able to prove that your patent is both valid and infringed.
In the second stage.
In the second stage. As a defendant, however, it's not and, it's or. So that is where the system means that as a defendant, you can say either the patent is invalid or I'm not infringing. Right. So you have two ways to escape as a defendant. Whereas as a patent owner, you've got to prove A and B. You got to prove both validity and infringement. And as a alleged infringer, you can basically say it's either invalid or it's not infringed. So that's a really kind of it sort of tilts the scales a little bit.
It's a good point, yeah. And I think it's worth mentioning, you may have mentioned already,